We're recording, so we're ready to begin. This is an affirmative constructive on the debate topic that the death penalty is unjustified. This affirmative constructive will be 8 minutes long. I have my timer set, and I am ready to begin. So, audience ready, judges ready? Time begins now. Now, there we go. Okay. In 1991, Troy Davis was convicted of the murder of police officer Mark McPhail. McPhail was working off-duty as a security guard at a Burger King parking lot. According to Amnesty International, quote, the case against David consisted entirely of witness testimony which contained inconsistencies even at the time of the trial. And although all but 2 of the state's non-police witnesses from the trial later recanted or contradicted their testimony, and, quote, many of those witnesses have stated in sworn affidavits that they were pressured or coerced by the police into testifying or signing statements against Davis, and again, quote, one of the 2 witnesses who has not recanted his testimony is Sylvester Red Coles, who was the principal alternative suspect. Despite all of these inconsistencies, Troy Davis was executed by the state of Georgia on September 21st, 2011. And the Troy Davis case is not at all unique or special. He was a black man convicted of killing a white police officer on dubious evidence, and his death outraged the entire world, as it should outrage the consciousness of every one of us in this debate today. Therefore, in this value debate, I stand resolved that the death penalty is unjustified. To begin, I should like to define the grounds for the debate. First, the context for this debate is the United States. It stands to reason that because debate is a real world activity, and because we as debaters and judges are in the United States, that we should be talking about our policies and our laws. I would argue furthermore that the United States is a reasonably just system of punishment, and therefore, if the death penalty is unjust here, it would be unjust in other political places and other political states with less rigorously applied rules of law. So basically, if it's not justified here in the United States, I'm finding it hard to believe that it would be justified in China or Iran. Right? 2, the death penalty means simply the infliction of death or the ending of life by the state, either a state government or federal government, as a form of punishment or crime. Now, what this means is that the operative word in today's debate is going to be unjustified. That's our problematic term. And again, there's no reason to get out an online dictionary. It just means not justified, right? So the operative term is going to be justice for this debate. And it's my responsibility as the affirmative to show that the death penalty is something that lacks or does not have justice. And that brings us to the criteria, the weighing mechanism for the debate. The function of the criteria is to operationalize justice, to provide a standard by which we can draw a bright line of distinction between the just and the unjust. I would argue that the most reasonable standard on which to base that distinction would be the U.S. Constitution, specifically the 8th and the 14th Amendments. Why do I believe this? 1, because the context of the debate is the United States, and 2, because the issue at hand is punishment. Okay, both the 8th and the 14th Amendments to the United States Constitution prohibit any form of punishment which is either cruel or unusual. However, as even a cursory study of the history of the 8th Amendment constitutional law demonstrates, these terms are difficult to define and certainly not self-evident. I would thus advance the definition given by Supreme Court Justice Douglas in his opinion written in Furman v. Georgia as printed in the Journal of Criminal Law and Criminology and Political Science, 1972, page 487. Quote, any punishment administered in an arbitrary or discriminatory manner is unusually imposed, Douglas contends. And Douglas went on to conclude that, quote, a statute apparently non-discriminatory on its face could still be applied so as to violate the 14th Amendment. Justice Douglas standard gives us a clear decision rule. Any form of punishment that is applied in a discriminatory or arbitrary manner is unusual and therefore in violation of the U.S. Constitution. Such a form of punishment would be unjustified by definition. This brings me to contention 1. The death penalty is discriminatory applied on the basis of race. So my first subpoint is that numerous studies confirm that the death penalty is discriminatorily applied on the basis of the race of both the victim and the defendant, according to Ronald J. Tabak, Human Rights, September 1999, page 5. There is a long history of racial discrimination in the use of the death penalty in this country. Indeed, racial discrimination based on both the race of the defendant and the race of the victim was a principal reason why Justice Thurgood Marshall joined the Supreme Court majority that held in 1972 that the death penalty was unconstitutional. Unfortunately, the modern post-Furman death penalty continues to be pervaded by racial discrimination based on the race of the victim and, in some places, the race of the defendant. This has been shown in numerous studies that the independent U.S. General Accounting Office, the GAO, validated in 1990. My second subpoint is that extra legal elements result in arbitrary and capricious application of the death penalty. This is according to Lenza, Keys, and Guess, writing for Social Justice in 2005, page 152. This analysis of capital sentencing over an 18-year period, 1978 to 1996, will demonstrate that defendants in capital trials did not receive equal protection under the law and that their fates are still subject to extra-legal elements that constitute arbitrariness and capriciousness. The remedies that they're talking about here are those envisioned by Furman v. Georgia, have not alleviated the problem of desperate treatment of minorities. And instead, the actual charging of suspects and prosecutor plea bargaining with defendants have systematically facilitated harsher outcomes for alleged assailants of white victims, and closely resembles what Poster called low-visibility decision-making. Furthermore, this analysis will support the view that Missouri's death penalty has changed very little in its essential character from the pre-Furman conditions. In its executions continue to be symbolic events with a racist character similar to the legal conditions prevailing in the state before the Civil Rights Movement. Such a system of institutionalized racism reserves its harshest sanctions for offenders of white victims, while unscrupulously waiving the heaviest penalties when the victim is a non-white, right? So the idea here is that if you are a white person who is killed by a black person, you're significantly more likely to end up in jail, and that black victims just simply do not get the same protection under the law, right? This brings me to my final contention in the debate today. Contention 2, that the death penalty is discriminatorily applied to poor men. This is supported by the American Civil Liberties Union in the case against the death penalty, December 11, 2012, in paragraphs 49 and 50. Both gender and socioeconomic class also determine who receives a death sentence and who is executed. Women account for only 2% of all the people sentenced to death in the United States, even though females commit about 11% of all criminal homicides. Many of the women under the death sentence were guilty of killing men who had victimized them with years of violent abuse. Since 1990, only 51 women have been executed in the United States, 15 of them black. Discrimination against poor, and in our society racial minorities are disproportionately poor, is also well established. It is a prominent factor in the availability of counsel. Philip Barron, this is also supported by Philip Barron, Gender and Discrimination in the United States Death Penalty System, December 18, 2006, paragraph 5. Timothy Kaufman Offshorn notes that Carla Faye Tucker and Junia Bazzino, executed in 1998, were added to the list of 39 women executed in the 20th century. With their executions, the United States recorded, over a period of 350 years, 533 execution of women. He continues, by way of comparison, there have been 19,161 confirmed executions of men during that same span. In sum, less than 3% of the persons executed since 1608 have been women. There are no women currently serving on the federal death row, and the total number of women in the state's death rows is 47. By contrast, there are presently 3,565 men on death rows across the country, with 23 impending executions among them. 77 men have already been executed in 1999. The disparity between the numbers of men and women executed and awaiting execution demonstrates a gross inequality that demands further exploration, which ultimately proves that these numbers do not. The inequities of the system adversely impact women. So, to just quickly summarize the affirmative position in this debate, a punishment cannot be a just punishment if it is applied in an unusual manner, that is, a discriminatory manner. It has to be even-handedly applied. I would argue this is a common sense standard for the definition of justice. If it's applied in a discriminatory manner, it is unjust by definition. And that is unjust both on the level of race, both the race of the defendant and the race of the victim, and it's unjust on the basis of poverty and gender status in this country.